Welcome to the Heart of Law podcast. My name is Mirena Umizaj, founder and CEO of Mirena and Company. My guest today is Texas attorney Marty Shellist. Marty graduated from South Texas College of Law in 1993. He has been a lawyer for 28 years, and he's partners at Shellist, Lazars, and Slobin. In 2013, Marty co-founded Virage Capital Management, an asset management firm which specializes in litigation finance. Today, Virage is one of the largest litigation groups providing growth and working capital to law firms nationwide. Marty is a unique individual because he has deep experience in legal and finance, and that is a hard combination to find in our business. I have worked with Marty and his team since 2015 and have truly enjoyed collaborating, learning, and growing together. Marty, welcome to the show. It's good to have you.
Thank you, Mirena. It's absolutely exciting to be here, and I'm so proud of what you're doing and glad to talk with you.
Thank you so much. Thank you. What is life like in Houston with the residual of the pandemic and the power outages you all experienced in February?
You know, life is returning to normal. It seems like Houston can't catch a break, right? We have Harvey a number of years ago, a once in a million year flood. We have this great freeze of 2021 in February, which left the majority of Houston without power and energy and cable, quite frankly. And of course, just storms all the time anyway, hurricanes. So Houston is incredibly resilient. And we're, I would say we're as back to normal as we ever are, because the only thing constant here is kind of the change in the weather. They say if you don't like the weather here, just wait a minute. So, anyway, everything's getting back to normal.
Yeah, same on that front with Florida. So I can see you're in your office today, but is your team fully in the office, working from the office, or are you doing a hybrid model?
So we opened an office in Miami, oddly enough, about eight or 9 months ago during the beginning of the pandemic. And we have several folks who work there full time, and they are in the office. In Houston, we have a greater number of people, although not too many. And some of us are here often and regularly, and others alternate days because that's their comfort level. And so our position is that people can be productive from anywhere.
Right.
And so we let them decide how often to be in the office.
Yeah, that makes sense. That makes a lot of sense. Most of the attorneys that I talk to are doing something similar. In fact, a lot of people are paying or renting as much space as they were in the past. So they've reduced the overhead, which is great. And as long as people are being productive, I don't think there's anything wrong with that.
I think this is the new normal, and it may trend back a little bit, but I think it's going to remain different for a long time.
For sure. Yeah. So Marty, for those who don't know you, can you expand a little bit on your background and why you transitioned from the legal into the financial world? Are you still a lawyer with your firm or a partner with Virage, or can you shed some color on that?
So several questions there, but I, as you pointed out at the beginning, became a lawyer in 93. And I didn't know during law school what kind of lawyer I would be. But through a series of events, I was drawn to labor and employment litigation and some commercial litigation. But I always liked fighting for what they call the little guy, right? I liked fighting for people that were picked on or harassed or abused in some way. That was always very, very important to me, and it just resonated in me. And I did that for a long time with some partners whom I absolutely love. They're like brothers to me. And we grew a boutique firm here in Houston, and we're involved in cases all over. Then in about 2011 or 12, one of my very dear friends of now 25 years, Edward, who's lived in the finance world during his career, approached me about an idea to provide financing to plaintiffs' contingent fee lawyers. And I was intrigued by it, and he was very persuasive, and I looked into it, and we started a business together, one that he had already begun investigating, and we launched in 2013. At that time, I was still practicing law full time, and I like to say, sort of, I had one foot in one canoe and another foot in the other canoe, and they were pulling in different directions. And so my time with the law, my time with Virage sort of switched over the year or two following 2013, so that by 2015, I was spending the vast majority, if not all the time, at Virage. I still have my name on the door at the law firm. I still mentor some of the lawyers there to the best of my ability. I still talk with my partners about cases the firm is working on. And so that's how the transition occurred.
Yeah. When I first started working in the litigation finance world, this line of business was frowned upon. And the law firms that actually dipped their toes into this kind of capital wouldn't necessarily talk about it. But today, this type of financing has become, pretty crucial, not only to sustain long-term litigation costs, but also as growth capital. And it's created tremendous opportunity for everyone involved. Virage has been around for 7-8 years now?
8 years in September.
So how has the landscape changed compared to when you first started Virage?
So when we started, as you say, lawyers were very cautious about talking with a lender that wasn't a traditional bank. Mm-hmm. They couldn't get their arms around it. And quite frankly, they viewed it back in 13 and 14 almost as though it was something that would create weakness if others knew that they were using. And after lawyers understand that the justice that they dispense can only be amplified with proper capital and resources, it changed everything. And I would say by 2015 to 16 is when things started changing. And now lawyers are very proud to say that they work with Virage. In fact, they tell defendants, we have a partner in Virage. We're not worried about you and the work you're going to put us through. You will not wear us down. Mm-hmm. And it has become, this badge of honor and a very powerful tool in the industry for that reason.
Yeah, I would agree with that. So for those listening and don't really have exposure to litigation funding, what is it? Can you give us a definition of litigation funding and how does it work?
Got it. So if I back up a step to how do lawyers finance their firms? Mm-hmm. Lawyers traditionally finance their firms one of several ways. They self-finance, which in and of itself is debt. It's just their own. It's complete recourse because if they lose it, it's their money to lose and it's gone. There is banking. Banking has been around as long as any other business in the world. And that is a source that lawyers typically will have a line of credit with. And the other way that lawyers traditionally funded was by partnering or JVing with other firms, which, while it has its benefits to work with other firms, if they contribute all the capital and you don't, you end up giving away half or more of your fee. But those are the traditional ways that lawyers would finance their firms and their cases. What litigation finance is, which is also called alternative litigation finance, is when you have a group like Virage that will look to the case collateral, right? Cases and future contingent fees that the firm has over the next 1 to 3 to 5 years. And it pulls some of those fees forward so that you can use them today to go out and market for more cases. You can use it to pay for case expenses. You can use it to expand your firm, hire more people, build out more office space, open new offices. And it does it in a way that permits you to retain as much of your fee as possible. And so that's what alternative litigation finance means. We were not born from banking. We were not born from investment banks or Wall Street, as it were. Edward had some experience on finance matters, and I was an attorney. And we came at this trying to create something that was new and that borrowed the best of all worlds to benefit lawyers, law firms, and most importantly, their clients. So that's what it is. I'm happy to explain how it works.
Yeah. Because, I get calls all the time from lawyers that have heard litigation funding over and over and over again, and will call me and say, well, how does it work? So you mean I need to give you something in order for you to give me this loan? Like, it's not like just applying at the bank. So I think it's important to keep emphasizing sort of the core use of litigation funding, how it works, and who is the best fit for it. Sure.
The best way I can explain it, I think, would be to talk about how we're different from a traditional bank.
Right.
When a lawyer goes to a bank, most often, for 95% of the lawyers, they're essentially borrowing their own money. The bank will say you have $1 million on deposit. We'll loan you that $1 million at 5%, and now go use it as a line of credit. And that line of credit, Mirena, can be called year to year, right? They can call it or not renew it. The other things that banks like doing is getting a personal guarantee, not only from your business, but from you individually. And it covers your stock portfolio. It covers your second home. It covers other assets that you have. Banks are not good at underwriting cases. They don't understand them. They'll ask you for case updates. They'll say, send us your case listing, but it's Greek to them. They don't know what they're looking at most of the time. What Virage does is it looks at your case inventory, not your stock portfolio, not your personal assets. And those are what become the case collateral. So, for example, if a lawyer has 500 personal injury cases or 500 talc cases, Virage would look at those, try to determine what the net fee interest of that lawyer or the firm is, and come at a valuation that allows us to advance capital. It's not a line of credit. If they borrow $1 million, it's loaned to them and put into their operating account at closing. And then they can use it, deploy it as they see fit for their legitimate business purposes. So that's really, when you boil it all down, how we are different. There's more to the story, of course, but that's essentially what we do.
Yeah. So what is Virage's traditional product? And is it just a one way where you underwrite, you see what the cases are, look like, evaluate, determine what you're going to offer against that collateral? Or is there other things where, you can be creative with how you're lending, how many parties can be involved, and things of that nature?
Great question. So I'll tell you that the main thrust of what we do is that a law firm, whether it's one or two partners or 10 partners, whether it's an AmLaw 100 firm getting into contingency fee work, or it's a 20 or 30 year mass tort firm or personal injury or other litigation boutique. And they will say, we have a basket of cases, and we will determine what is the ask. What is the amount of money the firm is looking for, and what does it need? Sometimes a firm will say, we want $10 million. And we come to find it's really only 2.5 a quarter if they need it that often. It may be 2.5 a quarter, but it's spread out now over 2 years, not 1 year. When you have a lender asking you to take less than more, I think you've got an honest and a good partner in that lender. So the lawyers will give us their basket of cases, and we will underwrite them. And we do that internally. We do not use a third party.
Right.
We have lawyers on staff, and through my experience and other team members, we will evaluate the cases. We will also underwrite the law firm and the lawyers. The reality is we're not right for everybody. Mm-hmm. Just as we're not right for everybody, not everybody's right for us. Yeah. But assuming there's a match after we underwrite the lawyers, we underwrite the cases, we will then make an offer for a loan. And that loan is at a stated interest rate. And that interest rate varies based on whether it's a pre-settled docket or some of the collateral is pre-settlement, or whether it's post-settlement, awaiting lien resolution, awaiting a QSF administrator, qualified settlement fund administrator, to pay out the monies. Mm-hmm. We look at whether a lawyer is an aggregator of cases, or the trial law firm, or the settling counsel, or are they in a joint venture with all of those together? Because what I think lawyers need to look at when taking financing is, it's good that you have 1,000 cases, but are you in control of your data? Are you in control of your case? Are you in control of reporting that you need? Set aside for a lender. You need it so that you know what your cases are worth, because $1 today is worth something different in 3 years from now or 7 years from now. So we come up with an offer, and then we will send that law firm a loan document. We're happy to send a term sheet if they want, but I prefer the loan document because that's where the details are. Mm-hmm. And by the time we get there, through help from people like you who work with so many great firms and work with us and others, we come to terms fairly quickly, and then we close. And so that's the process.
Yeah, that's what I love about your group. It's just been easy to communicate with the decision makers, right? Versus having to go through layers and layers of people who are underwriting outside of the actual company. They're hiring a third party, and something that could take about 2 to 3 weeks takes 60 to 90 days with really no guarantees that a deal is going to happen. So part of me enjoying working with your team has been that, okay, here is all the information that you need required to underwrite. Can you please give me an answer sooner than later, right? Because nobody wants to waste time. So that's been always a huge positive working with your team.
But you do a good job as well. And I say that with all sincerity, because you prepare clients and you let them know what to expect. And so it's not a big surprise. I mean, the reality is, I'm not saying that Virage should be the sole support for any firm. You could have a little bit of banking, a little bit of self-finance, but Virage sprinkled into the mix always helps. Mm-hmm. And you always educate your clients, and it makes our job easier.
Thank you. I try. I think most of the time, I spend an average of about a year with any given client. Sometimes it's less or sometimes it's more. But I would say average, I spent about a year building relationships with attorneys, because at the end of the day, you can talk about shop and you can talk about terms and you can talk about, how a product works. I think ultimately people crave a connection even with the people they are working with. And I say this, sometimes people laugh when I say this, but to me, business is a spiritual practice. This is a place where we go to express who we are, and how we do business says a lot about who we are. So spending that time bringing people up to speed with the evolution of all these new different services that come into our industry, and getting them to see the different options, and then allowing them at their leisure without pushing and saying, you have to do this now, you have to work with this lender or that lender, but allowing them to make a decision has really allowed me, given the clients that I represent, the trust in me, and then, the parties that I bring to the table. So you've always made me look good, Marty.
Thank you. I appreciate it.
So, what do you look for in an individual attorney or law firm in terms of qualifications? Inventory aside, can you expand on what a lawyer, what the profile needs to be for you to overcome that sort of hump?
Yeah, there are some very obvious things that we look for, or quite frankly, look for them not having. So if you have a lawyer that has been disciplined by their state bar in at least the recent past without explanation, that's a problem. Mm-hmm. Quite frankly, if they're disciplined at all in their career for a serious enough offense, that's a problem for us because that speaks to the ethics. For example, if a lawyer was disciplined 15 years ago for absconding with clients' funds, you never recover from that in a lender's eyes. Yeah. I might like you as a person, but we have a fiduciary duty to our investors we take very seriously. And some of this is our capital as well. And we don't want to deal with people that don't care for their clients as we would care for them. Yeah. So that's the first thing. The second thing is you would like to see fiscal discipline of some manner. The people who make the most money with Virage's capital are those who understand that Virage's capital should be used as an accelerant to growth, right? We provide them seeds. Do they squander them? Do they set them in a dark closet? Or do they plant them and nurture them? The lawyers who nurture the money, the ones who invest it with an eye towards a return on investment, a multiple return, are the ones who make the most money with it and are inarguably the happiest with it. So having fiscal intelligence is helpful. Now, that doesn't mean we only deal with MBAs. That doesn't mean, you have to be a JD MBA. But if a firm has an internal or external CFO, that speaks volumes because it shows that they care about it. Lawyers who try to do everything themselves are not the best borrowers. And they may not care because their life is fine and they're generating revenue. But we like fiscal intelligence. I think that that's important. And again, it doesn't mean that they themselves are an accountant, but it means that they bring an accountant to the first meeting or phone call so that we can all be on the same page with the needs of the firm. So I would say in absence of pockmarks on their reputation, making sure that they are somebody that we like working with, somebody that is trustworthy, and at the same time, somebody that is going to use the money wisely. And then the last thing I would say is someone that is a good lawyer. That doesn't mean that they're on the front page of their state's bar journal every week. There are examples of those people whose stars rose for many years and fell spectacularly. So that's not what I'm saying. I'm saying we want lawyers who have a steady track record of doing good work for clients. That's what we look for. And there are so many lawyers who meet all of those qualifications. I think the opportunities are boundless. So,
yeah. Mass torts can be a controversial area of law sometimes because, it is representing clients en masse. And so that's very, very different from, a single event practice and their approach that they take with their cases. So you have this mass, class of people that you're representing. And I feel like a certain category of people is attracted to that, right? And so it's fairly new in the sense that new money is coming into this area of law. And so a lot of people struggle with wrapping their head around it, right? To offer good quality service to these clients that you never meet in person. And then you're borrowing money based on the future fees. Do you find that there is sometimes some disconnect because there is such a distance between the law firm and the clients that are being represented, especially if they're being referred from one firm to another. You kind of lose, like you said, the personal touch on those cases. I don't know if my question makes sense.
Well, your question makes sense. I could answer it from, we deal with hundreds of law firms around the country.
Yeah.
Some of the most well-known to some of the more obscure, very successful firms that nobody hears of because they stay under the radar. So I could answer it from our experience from the lawyer's voice,
right,
or how a lender sort of views it. Which would you like?
Both would be great.
Yeah. So, there are programs out there, some very well known, that are meant to educate, for example, personal injury lawyers on getting into mass torts. Mm-hmm. And I think they're good because it opens the lawyer's eyes to how daunting it can be. If you don't talk with someone like Virage or Mirena Umizaj or some of these other programs, if you don't do your homework in this space, the lawyer finds themselves getting access to $1 million. They aggregate 300 clients or whatever the number is, and they don't know what to do with the clients. And maybe they refer them to some firm. Maybe that firm is known to be responsive. Maybe that handling firm is not responsive. And it does create a disconnect because the lawyer who signed the clients up maintains that attorney-client relationship and a fiduciary duty to them, which as a footnote is why, Virage's Capital, we view it as so important because it helps the lawyers dispense justice, but they have to use it wisely. If you used all the money to generate cases and saved none to work up the medical, to have settlement packages prepared, to hire experts, right? Now you're in a weird position. So as much as we lend money, we like to consult with and talk to all of our borrowers and even firms that we don't loan money to because educating the marketplace lifts everyone. Yeah. So the lawyers can become distressed if they get into this situation where there is a disconnect. They just do. Yeah. From the lender's perspective, and of course, Virage has gotten smarter in the last 8 years, a little wiser, the gray hair, right? But because firms that aggregate and do nothing else can be wonderful borrowers if their corresponding contracts with the handling firms are written properly to get reporting on case status, to stay in touch, right? If all an aggregator does is pass them off to a handling firm and wait for a check, you're not a lawyer. You're not. And we won't loan to you. You have to demonstrate, at least to Virage, that you have involvement and that you are on top of the data to some degree, because controlling the data is controlling the value. So, we have certainly learned a lot over time, and I know you have as well, but the mass tort world is a whole different landscape from any other area of law, and it is as much a business as it is the practice of law that you'd ever find.
Yeah, I agree with that. So just to give you a little perspective, when I'm around at these conferences and around other companies that are offering services, including the companies that do case acquisition, I think what's missing now, having this conversation with you, is that a lot of lawyers are sold on, especially single event lawyers, that just see mass torts as a way to diversify and invest, become a passive investor. Is that when they're being approached initially, they're being told, look, if you've got a healthy docket of single event cases, you can use that to get some capital out. You can run a campaign in mass torts, get the cases, refer them to the best handling firm in the country, and then sit back and wait for a check. That is what they're being sold on at the very onset. So I don't think that, these lawyers getting into that position where they are sort of passive investors are doing that with the intent, of not wanting to do any work. It's just that they signed up for that model. That's what was presented to them.
Right.
So how do we change the conversation? Because I'm part of those conversations, building the business model, building the vision. What would you say before somebody decides to do this? What do they need to take into account? And if they didn't want to become an active or a handling firm, should they completely stay out of it? Or is there a way to do this that's productive for everyone?
So I would answer that question, which is, again, a great observation, a great question. How do you fix that situation? And what should a lawyer do? I want to start my answer by saying that lead generation companies and marketing companies serve a very important role. And most of the ones that I know of do a good job. And borrowers of ours work with them. And it's tried and true. And there's no funny business. And it's a good process. The reason why the marketers, Mirena, are so important is because they are letting the old lady in her chair in Pasadena with a defective hip know that it's defective. She may not find out otherwise. She may not. And if she doesn't have that information, she's not going to come forward. And I would, as another footnote, just say that in the last 8 years, the number of cases that find themselves in mass torts, whereas 10 years ago, the average mass tort may have had 500 to 2,000 members. Today, they can have upwards of 50,000 to 200,000 members. And I'm not saying every tort has that many users, but there is clearly an effect and an impact from the marketing. Now, when lawyers are told just sign up, you'll get 500 cases and give it to the best firm. I'll answer that part by saying what we do. When a personal injury firm comes to Virage and says, we want to borrow money, we want to get into mass torts in part, we go through hours and hours of talking to them about which mass torts. You should have a long-term, medium-term, and short-term goal. If you get into one tort by itself, your odds of succeeding are far less than if you have 3 or 4 torts. Number one, which torts? Number two, which firm or firms will you deal with? Which ones are known to communicate? Which ones are known to pay you first? Another example, you don't want to give your cases to a firm and let's call it IVC cases. Call it TVM cases from the past, which are still being paid out. Call it the upcoming, the talc cases. You don't want a firm to take your 500 or 1,000 cases, put them at the back of the line for payment so that their cases get paid year 1 of the settlement, and you come to find out you're in year 4 or 5. So we educate borrowing firms on how to have those discussions with the handling firms, the settling firms, the trial firms, so that they can contract in a co-counsel agreement to get the benefit they think they're getting. Now, should aggregators stay out? No. That's the only way they're going to learn. Therefore, they should get access to the handling firm. I want to be on some calls that you're on. I want to hear this. I want to hear that. And so I think firms who are looking to be educated should start by aggregating some cases and working with good firms. But they have to go into it with eyes wide open. And so if you and I and others start telling people, don't take money, don't aggregate unless you do it in this way, if we don't do that, the world isn't going to change.
Yeah, I think it's worth having this conversation truly with the marketers, because that is where the attorney is getting the first piece of information about mass torts. They go to a conference and then they meet all these different vendors, and they hear this conversation. They see other people doing great in mass torts. They see there is volume. And, so that is the entry point. So we need to educate. I think the legal finance world needs to educate the marketing world in terms of how to have those conversations so that there is not, it's wasted time, right? Because if I bring somebody that is saying the wrong things and you don't decide to work with them, then it's a wasted time for everybody involved. So how do we educate and elevate the industry, as you said? So certainly something that has planted a seed with me, and I'm cautious as I navigate that subject.
Yeah, I would add that the lawyers that have been in mass torts for 20, 30 years have visited with me on occasion about a concern that lawyers who don't know what they're doing get access to capital, and they aggregate bad or what ultimately are valueless cases, and it gums up the system. And, you know, as I just mentioned a moment ago, Virage will not loan money to a firm who plans to operate in that manner. That's just not our MO. At the end of the day, we want to see our borrowers succeed, and we give them all the advice we can. I mean, in addition to being a lender, we also, because we've dealt with hundreds of firms around the country, we have connections in almost every area. So past borrowers, current borrowers, to say, hey, you need help with this? We've got the folks on the steering committee doing that. And they will sit with you and they will educate you and they will give you a fair deal.
Right.
So it ends up becoming an ecosystem geared towards success.
Yeah.
It helps the tort resolve. It helps the lawyers make money. Most importantly, and I can't underscore this enough, it helps the clients get to resolution more quickly. And we take that to heart. I mean, that's what, we wouldn't be here if there weren't clients who needed help and we weren't aware of that. So.
Right. What type of inventory does Virage focus on right now?
So our practice is geared today to loan money to primarily contingent fee firms that have an interest in contingent fee inventory. So in our portfolio of cases today that sit with the lawyers that we've loaned to, there are many, many mass tort matters. Almost everyone under the sun likely sits within our, I'm calling it a portfolio, but within the cases that are the lawyers handle. And I need to drop another footnote. We don't give value to every single mass tort, but lawyers who give us a number of cases may give us early stage, middle stage, and late stage. And we take it all into the inventory with a combined value. But lawyers who are interested in seeking funding from us or others should package together their entire docket of cases in which they have a contingent fee interest. And then let's have a dialogue about it. We're not interested in a land grab, but if we can give 2 times more value to 10% of their cases, why give us the other 90%? Whereas some firms may say, oh, I'll only give you this 10%. Whereas we say, well, we need this other 20%. You know, a dollar is fungible. It doesn't matter where it comes from on their docket. They should not care about it if they have good financial advice. So contingent fee cases, mass tort, personal injury, breach of contract. We'll look at intellectual property, IP cases. We'll look at employment law, wage and hour. We'll look at False Claims Act cases. We'll look at almost any kind of a case that's out there. But what we like to do is to look at more than just one single case. And again, the lawyer should be looking when they borrow funds to pay it back as quickly as possible, because the interest of any loan of any kind, even their own money, interest accrues. And so we would look for a basket of cases. It could be 3 matters, it could be 5 matters. In the case of mass torts, it could be 10,000 matters. It depends on the amount being sought and what those underlying cases are. That's how it typically works.
So I was talking to an attorney this morning, in fact, and I was educating him about litigation funding. And he had heard about it. He knew he wanted to do it, but he didn't understand how the interest was charged. And his assumption was that he was going to be charged multiples, or he was going to share his profit, his fees at the end when everything was said and done. So can you speak about the different ways that money is charged on the loan that's received?
Sure. The principal way that Virage does it is by just charging an interest rate. It's very, very similar structurally to what your bank does, but without all of the strings attached. There are other terms and conditions, of course, but we operate very differently than a traditional bank. There are lenders who specialize in charging multiples, for example. So if you borrowed $1 million, they may want $2 to $3 million or more back first off the top before you start sharing in anything or before you get anything, whether it's all of or part of the end. Multiple deals can be, and they are incredibly expensive based on how long a tort takes. Quite frankly, the shorter a tort takes, the more expensive it is, of course, because you're paying that fee. Those lenders also seem to have what's called a prepayment penalty. Virage does not have a prepayment penalty. That is a word that every person that listens to this should research and look up because it adds to what we call the cost of capital. And that's the name of the game. How much are you paying for every dollar that you borrow? You want that to be as low as possible while working with good people on good terms. So multiple deals typically carry a prepayment penalty. So if you pay it back within 24 months, you owe 10 to 20% of the interest they would have earned anyway. It just doesn't, it makes things so expensive. It's prohibitive for many people, whether they realize it at the time or not. What you mentioned about the revenue stream basically is a transaction that typically involves a lender that purchases future fees. Okay. And in doing it in that way, if they purchase future fees, what that can do is they can receive favorable tax treatment for acquiring something, and they've given you cash for buying something. So you have to talk with your accountant about whether that is income. Are you paying tax on it? Because if it is a debt instrument and a loan, which Virage's traditional products are, you can get an interest expense deduction, typically. Yeah. If it was a purchase of fees, you may have the reverse effect where you're paying taxes, not getting a tax benefit. That's why your accountant, your CPA should be involved in these discussions early on. But that's how it works. Virage, that is certainly not something that Virage is active in. Our main product is an interest rate-based product.
So what do you think about the funders that come into the space and they want to share fees with attorneys? Can you speak about the ethics of that, or is that something that you can't expand on? Or?
Well, I'm not an ethicist. I can tell you that as a lawyer, I know that, if a lawyer were to share fees with a non-lawyer, there is an issue, right? Certainly there can be an issue with that. Right. There's also been the growth of firms I've heard of that operate out of, for example, DC.
Yeah.
And there are different rules in DC. We don't operate anything there, but my understanding from groups who do is that non-lawyers under certain terms can participate. And in doing so, they can share in some of the fees. Mm-hmm. There are legal structures that much smarter lawyers than I can talk with you about how litigation funders can operate, whether it is from an interest rate all the way to the purchasing of that future fee asset. That's not my bailiwick, but it is definitely something that lawyers should check on as they look at who their lending partner should be. I mean, they should be looking into not only the financial aspect, but the ethics aspect as well.
Have you heard of the courts inquiring on these arrangements, or are you familiar with, judges getting involved and inquiring to what extent a fund is involved, whether or not they're trying to dictate the outcome of these cases? Because I think that's where this sort of conversation leads to, is whether or not, the people that are funding get to make decisions about matters that, they're not necessarily working on every day.
Right. So great question, because there has been activity in that regard. But if I back up one step and then I'll answer that, when you have a line of credit with your bank and you're a law firm, you receive fees in, right? And you pay down your loan with those fees. It's a legitimate banking transaction, right? You're not sharing fees in a traditional sense. There are other issues that can arise if, as you put it, and I'll segue into what you were talking about, where a lender says, we want to tell you what experts to hire. We want to tell you when to settle a case. We want to be involved in a host of decisions. Virage is never involved in any of those decisions. And in fact, our loan documents say we are not involved in any of those decisions. We're just not. We want to work with lawyers we trust. The opinions that have come out over the last couple of years have been defendants who are itching to understand what the financing arrangement is with a law firm. It bothers these companies so deeply that firms can now compete on a level playing field. Mm-hmm. And they go to the courts, and a couple of those cases have resulted in judges who will say, we're not getting into any banking relationships, just as we won't, defendant, get into your finances.
Yeah.
But we will say that if a lender has control over any aspect of the litigation, that's a no-no. It shouldn't happen. It's not good. And the courts may, in fact, strike down or rewrite some of those loan documents. We've seen that. But again, that's not the world that we play in. Mm-hmm. Mm-hmm. So that for sure is out there. And lawyers who are considering alternative litigation finance should absolutely view any of those controls as a red flag.
Right. I agree with that. So you mentioned the bank, and I want to dig a little deeper there, because I think this is also an important point to make and educate folks about the difference between working with your bank, getting a line of credit, and doing alternative legal financing. Excuse me. So what is the difference between having a line of credit in this business versus using your money?
So when a bank loans you money, and I alluded to some of this before, but when a bank loans a lawyer money, typically all the partners of the firm sign guarantees committing personal assets, assets at the bank, accounts that they have with the bank are pledged. There is some pledge of some asset beyond the case collateral. And a line of credit, most lawyers would know this because they have them. A bank will say you have a $5 million line of credit. It will renew every year. If the economy goes weird, we may curtail it. So if it was 5 million, next year we could tell you to make it 3 million, and then you have to pay down 2 million. You pay interest on the money that is outstanding that you draw down on the account, and you pay it back via what are called debt service payments, which traditionally are either monthly or quarterly. So if you borrow $5 million at a stated interest rate, whether or not you have income, you at a minimum quarterly basis, could be more frequently, are making payments, whether it's $50,000, $200,000, $400,000. You're making some payment based on the amount you borrowed to the bank, rain or shine, right? So there is this old analogy that, banks like to give you an umbrella when it's sunny out, and they take it away when it starts raining. And Virage views things a bit differently. We give you an umbrella, and if it starts raining during the term of our, let's say it's a 4-year agreement, we don't go and grab it back from you. We don't take it away. In fact, that's why we are there. Some lawyers may double down on an investment while it's raining. A case takes longer, right, but they're ready to get in. And so we do not have mandatory debt service. So if a lawyer, in my example, borrowed $5 million against several torts, and they had zero revenue from those torts for 1 year, zero revenue. They don't make quarterly or monthly payments to us. They pay us as and when money comes in on those torts. Now, we give the lawyers the flexibility of paying us voluntarily if they want along the way from other cases that they have, right? We have no prepayment penalty. So if you happen to win the lottery and want to pay your debt down a little bit, you do that. We want to be as flexible, as we can. But that's the major difference between a bank and Virage.
Why do you think banks haven't seen the potential? Or do you think, it kind of blows my mind that you've got a firm that's generating, $5, $7, $10 million, and they're limited to what, they can actually borrow from a bank because the bank won't even give them their money back at 5%. It's very outdated. Do you think that the landscape will stay the same in that regard, or have you seen banks trying to compete with funders like yourself?
I have seen in the last year, banks, and even before then, right? Some of the global leaders would have started to get into this 5 to 10 years ago, dip their toe into something, and then kind of went away. But I am seeing traditional, regional, local banks in different areas start to say, okay, you are a PI firm, and you come in and out of cases every 12 to 18 months. Your pipeline is such that you have good cash flow. We'll give you a working line for case expenses. That's it. Nothing else. That's the only thing. And it is under very, very restrictive terms at, a reasonable interest rate, I would say. And they're starting to look at lawyers in that way. They cannot get their heads around mass torts yet, and they can't get their heads around other lending. But even with what I've said, they still mandate a complete guarantee of personal assets. Virage does not ask for a guarantee of your personal assets. We do ask for a guarantee that as money comes in, as money is owed to Virage, you guarantee you're going to pay it because the law firms operate only through the individuals that operate them. But we do not tie up stock portfolios and second homes and the bank accounts of the firm. So I do think that banks are catching on. I think, quite frankly, we do what are called intercreditor agreements on occasion. Not all the time, but let's say that a prospective borrower has a $2 million line of credit with a bank, and they're looking to get into a bigger position on mass torts. They may come to Virage for $3 million. We, Virage, will then work with their bank so that the borrower can maintain that line of credit. And this intercreditor agreement lives together, right, with their agreement and our agreement. And it's really a document that's it's a game plan so that if things go weird, the bank knows what it gets, Virage knows what it gets. But so long as there is no catastrophic event, we live in harmony. And so we will work with lawyers to stay with their banks. I think that's not a bad thing. So
interesting. Yeah. So there are a lot of moving parts with litigation finance because when a tort is settled, that doesn't mean that it will start paying right away. And I think you mentioned QSFs and lien resolution earlier, but can you elaborate a little more on how these post-settlement details affect the repayment of the loan, and what can somebody expect when a case is settled?
That's just a great question, especially for lawyers who haven't gone through it before. The old saying that a case will cost twice as much to handle and come in at half of what you expected.
Yeah.
And if you follow that adage and maybe add some, you'll be far safer than just shooting for the moon and spending money you haven't earned yet. So basically, lawyers aggregate cases. I don't care if it's 3 cases. Someone in the country had the great idea, and I know who it is, for the NFL concussion cases, for example. Some lawyer in the country had the great example with his family stumbling on what became the talc litigation 10 to 12 years ago. So you talk about overnight successes. That's been 10 years in the making. And then you add the mesothelioma component to the talc litigation. And that's how these cases start. And after a couple of years, they get traction because you have to prove the science of the case. You got to have experts. And so some of these forerunners of the case dig into it, 3 or 4 firms, and they hire the experts and they get traction and they talk to the defendant. And maybe like in transvaginal mesh back in 2012 or so, 2011, some of them settled their docket. And some laughed at the time and said, "Oh, you settled it so cheaply back then." And they went on to aggregate more and try fantastic cases and get great verdicts. And again, they're friends and they do so many great things. But once the fire starts, once the cases gain a little bit of momentum, then you see the market move. And that's when most, not all borrowers, a lot of our borrowers are tip of the spear. They are the ones who are the progenitors of these cases, but certainly not all. And so the vast majority of firms, Mirena, will come in. Once that fire and the smoke starts, they aggregate then these cases. They're filed as the mass tort. A jurisdiction is selected. Believe it or not, there's a pool of federal judges in the U.S. And these cases get handed out to those judges who have deep experience and who want these cases. That's how it generally happens. And then steering committees are formed. And that's just jockeying for position. I think one of the folks you had on speaking on a previous podcast talked about diversity becoming more evident on these steering committees. That's a whole separate subject, which we, Virage, have been in favor of, greater diversity by race, national origin, and gender since we started. And that has its roots in me being a labor and employment lawyer fighting for these rights. So in any event, these steering committees get formed, and then people start saying, let's borrow some more money because it looks like things are shaping up. We've got a judge who knows what they're doing. We've got a tort with good science. We've got a steering committee made of people who know what they're doing to bring this to fruition in a relatively reasonable period of time, which is 3 to 5 years. And let's get into the case. Okay. So that is setting the table. You haven't begun to eat yet.
Yeah.
Because then the bellwether trials start. And the bellwether trials get set within generally a year to 18 months after, the steering committees and just, you begin a little bit of the disclosure work, but then trials get set. Maybe it's 1 to 2 years after the cases are really in their early formation. Mm-hmm. Now, you didn't ask me about all this part, the beginning part, but I'm leading to answer your question.
Yeah, no, it's very helpful.
Well, but then the bellwethers start. And we just saw with the 3M litigation, those first cases resulted in several verdicts. And they're great verdicts. They really are. I know some of the lawyers involved better than others, but the team of lawyers leading the 3M litigation are incredibly talented, business-minded lawyers. It's great tort. And it's one that has developed over time that Virage wasn't always able to provide value to. But now, bellwethers, and those go well. Well, they're going to be more likely. And they don't have to all go well, but enough go well. Discussions start with the defendant. The defendant at some point comes back, and at some magical moment, within a year or two of the bellwether, a global resolution, an MSA, a master settlement agreement, can be reached. Now, defendants can try to pick off some of the larger firms throughout all of this process to settle it, because it's like taking legs out from your chair. They want to weaken the foundation. But at some point, if a global resolution is reached, I'm picking up now where your question began. Lawyers think there's a settlement. Let's get in the case. Yeah. I can tell you that some of the first settlements on transvaginal mesh occurred in 2014, with some of the larger multi-billion-dollar settlements, 14 and 15. They were supposed to all be paid out by 16 and 17. Well, we're 4 years later, and some monies are still being paid out. And I'm not pointing the finger at anybody. It's just bankruptcies of clients, lien resolutions have to take place. So when a settlement occurs, money will then go into a qualified settlement fund by court order, or many qualified settlement funds of private firms litigating outside of the MDL, the multi-district litigation. And that money being deposited is nifty. It's great, but there are, good friends of mine who run very big fund administration companies, lien resolution companies, and you see them across the board in the NFL, transvaginal mesh, and many others. And, it's a lot of work. It is a ton of work. So the time it takes from a settlement occurring until money actually hits someone's account, that can vary wildly based on where you are in the pecking order of getting paid. I alluded to that at the beginning. I mean, if you're a handling firm on the steering committee, right, with a big docket, you're in much more control of the financial angle than if you were an aggregator who handed the cases off to someone else down the line. Mm-hmm. So it can take anywhere from, 6 months on the very, very, very early side, all the way up to a number of years. And that is after the settlement is announced. Mm-hmm. So, it's lawyers who are interested in getting into mass torts who don't have a pipeline of short, middle, and long-term projects, they absolutely need to. One of the bits of advice we give our borrowers, you have to have cash flow. Yeah. Do not look to Virage to pay salaries of your staff over the years. If you put Virage money into marketing and aggregating return on investment at a higher level, instead of paying for experts, you're so much further ahead. Use your own capital or bank capital for just the day-to-day overhead. I mean, maybe some of Virage capital for that, but the vast majority should be to plant those seeds, because if you don't have cash flow and you thought you were going to wait a year or two, that turns into 3 or 4, and the money comes in half of what you expected. It's not a happy day. You gotta plan for it to make it successful.
Yeah, so I would say, and all of that is just really gold information. I think attorneys need to tune in and understand what this really means. But I think it takes two to tango, because initially when the capital sources were being established in this space, they weren't really looking that far ahead initially. So it was a lot. The conversations were simpler. It was more about qualifying a client and getting them the money that they needed. And to be honest with you, I didn't start understanding the cash flow issues until later, when the first round of capital would be deployed. And then the firms would take the money, very eager, wanting to put the money to work. And then 6 months later, they were basically out of cash. Right. And so the lenders had to make a decision if they had to come to their rescue again, or if they basically said no. And I think this is where sometimes it could go wrong. So my follow-up question would be, what percentage, or if we could do the percentage, or, how much of this is on the lender and how much of it is on the borrower?
Well, I mean, I would say 100% of the analysis should be on the lender because it's their capital going out. Mm-hmm. It is for the lender to ask the right questions. Now, if a borrower misrepresents something or miscommunicates something, that can lead a lender to make decisions they wouldn't otherwise make. But a smart lender, has to ask all of the right questions and really know their audience. So we've been doing this for almost 8 years. We have relationships either as borrowers or just as friends with the firms that filed the first cases in almost every tort, the ones who settled almost every major tort in the last 6 or 7 years, and the ones who really have the information on, I don't mean confidential information, but they know what they're doing. They have information to let them make good decisions. So if we say, are you looking to joint venture with others? If you are, let us know. We trust them. But to answer your question directly, I think the lenders bear the responsibility for being educated. And there's a lot of money in the space today that does not understand that fully. It's not their fault, but they're not lawyers. They are bankers. And they think having a very, very strong 100-page loan document insulates them. And it doesn't.
Yeah.
It just doesn't. You have to have the relationship and the knowledge and the performance before anything, I think. So.
Yeah. And you personally and your team do a great job with that, with staying in touch and communicating these issues to your clients. So I'm grateful for that, because knock on wood, I haven't had, any issues. I mean, there's been maybe 1 or 2 exceptions, but generally speaking, I haven't had a firm find themselves in a situation where it didn't work out for them. So I take the same approach, is to understand what the vision is, what the blueprint is, what the business model is. And if I don't hear that a lawyer or a firm has a path to where they want to get and understand all the moving parts, then we don't apply for a loan. We have to start at the basics, and we have to understand, because I know that the lender needs to hear the story. What is the story of the firm? What is the firm trying to accomplish? What is the firm ultimately? What is the impact that the firm needs to make? So I think those are all important things to raise. So where do things go wrong for the law firms? Can you expand on that?
Yeah, I think you touched on one sort of key example a moment ago, that lawyers, they don't plan. They take the money. Mm-hmm. Virage is not a Monday morning quarterback as much as, trying to be helpful to the firms, but we're certainly not a backseat driver either. Mm-hmm. We trust the firms that we work with to deploy the capital appropriately. And there are conditions in our loan documents to use the capital for these business purposes that support the firm, the cases, the marketing, all of that. So it's a broad mandate, but it does have its boundaries. And firms who fail to plan, for example, if they borrowed $1 million and they put it all into marketing the next day, and they pledged their personal injury portfolio, they were used to running on 100% of that cash flow. In the Virage model, they will share part of that cash flow, meaning it's a waterfall, right? So part of that cash flow repays their debt, just as they would make a payment to a bank quarterly or when the bank demands it. With Virage, you're not making that payment when you don't have cash flow. But if you get a $100,000 check in, you're going to overage some sum of that. Whether it's 40% or 60%, you're going to overage a share of that to repay the debt. And Virage knows that going in. And so we may say, what do you need to operate? Let's protect that. Do you have enough in excess to service the debt when money comes in? So we work with you, we work with your clients And we have that discussion early on. So one way lawyers go wrong is giving up on what brought them to the dance to begin with. They take their foot off the pedal on PI, for example, and they are working on mass torts, but they don't realize it's a 5-year payoff. That's one way. The other way is not taking advantage of all of any tax benefits, whether it is an interest expense deduction, whether it is sharing any of the interest. Again, I encourage anybody listening to this to consult with an ethicist in their jurisdiction and or with an accountant or tax advisor otherwise. But with that caveat, there are some lawyers who say, well, I'm in a joint venture. It's 50-50, but it's my money. Well, if you borrowed that money from Virage at an interest rate, are you sharing that 50-50 with your co-counsel? Oh, no, I didn't even think about that. Well, why not? So you have to build your contracts with co-counsel and joint venture partners so that they share it. Now your burden is halved. There are some jurisdictions that permit you in the right circumstances to share some amount, albeit a lesser amount, of some interest expense with a client. Again, just check with your ethicist. It's permissible in the right circumstances. So my point is, they fail to plan for their economic future, and they're not taking advantage of benefits that would, inure to really their success in the long term. The other thing that they fail to do, Mirena, is they pick the wrong horses. They pick the wrong torts. They pick the wrong jockeys on those horses. And they either have good torts with bad jockeys or, bad torts with good jockeys, or bad torts with bad jockeys. But either way, by jockey, I'm talking about the handling firm that they entrust their cases to. And any one of those combinations will cost you a lot of money. Yeah. And that's why diversifying your portfolio, I tell lawyers that all the time. Don't spend $1 million on one tort. Put $300,000 into 3 torts. Yeah. So.
Do people call you asking you advice on what to get into, what mass tort to get into, and who to send their cases to? Do you get those calls? Because I do.
Yeah, I do. I get those calls, not infrequently for sure, not all the time, but I get them. And whether it's in the context of a borrower discussion or prospective borrower, or it's just contacts, colleagues, they may be an existing borrower, just somebody who knows of us. And, I like connecting good people, right? So I may send someone your way. I may connect a lawyer who is a newbie who comes to us wanting to borrow money with a basket of cases. I connect them with a firm that I know is on the verge of settling, that has information, and they can work together. And then they can make that decision that way. When it comes to which case should I get into it all, rather than me answering, I'll give them 3 lawyers' names to talk to about 3 different torts. And then they'll have the dialogue themselves. It's we just want to be helpful in any way that we can. And we really enjoy what we do. And it makes us happy when things work out.
Yeah, certainly you want them to be successful so you can be successful. The good thing about this business is that in order for it to work, everybody has to win, right? It can't, if the lender is the winner, then you won't have a repeat borrower. And if the borrower is the winner, the lender won't lend more money. So it's got to work for everyone. And I have identified as a key piece to make this successful is to really know what you're getting into before you get into it and speak
Absolutely.
to people. I have lawyers that want to get into, and I'll set up, multiple calls with multiple attorneys that are seasoned in mass torts, for example, and just have them talk about the business model and the approach. And, I ask them questions like, do you see yourself trying a bellwether case because you're a trial lawyer and put your trial skills to work? Or do you just want to be passive or, identify what you want to be, who you want to be in the space?
Right.
And I think some of the questions, it's funny because I've created a little questionnaire that I'll send to my clients, my new clients, and say, answer these questions. What is important to you? Is it impact? Well, rate and order. Is it impact? Is it profit? Is it excitement, adventure? Because certainly this business can provide that, right? People come into mass torts because it feels it's an exciting industry to be in. There is a lot of opportunity. There is a lot of, new money coming in constantly. So people come in very excited, just wanting to be part of the circle. And then they figure out the pieces. So, I feel now I can speak like an insider after being in this business for a long time. And yes, it can be a lot of fun, but please know your homework, know what you need to work on and need to do before you pull the trigger so that it doesn't negatively impact you and the industry as a whole.
Right. I think you certainly qualify as an expert after all of your experience. I agree with you. I mean, I think that when I talk to borrowers, I don't talk to them about taking money. I talk to them about who they are, and I talk to them about what they need and where they're going. Yeah. We say no to 90+% of the folks who seek funds from us. And that's not meant to deter anybody. It's just meant to paint a picture that if we are not a right fit for you, or you are not a right fit for us, you should find someone who's good for you. And, we don't want to take on that responsibility. Even if we made profit, we want to make sure that our product squares with what it is that they're trying to accomplish. So, I completely agree with you. I feel as though these conferences should absolutely have as a major focus, this element of education on your firm operating and taking funds, because as I've heard from a lot of these big firms, some of whom are deeply involved in these conferences, that education would save them heartache when they're trying to settle a tort, when they realize 20% of the cases probably shouldn't have been signed up to begin with, or have lower value, should have been worked on differently. Yeah. So I couldn't agree with you more.
Yeah. So you should send me the 90% of people that you turn down so that I can help them create a path. So 2 years later, I can present them again.
Absolutely. Yeah. I think I've seen a couple of names twice from you.
Yeah.
But no, it's good. I mean, I would tell you that there are some lenders, for example, who only want to loan X million, $20 million is their budget, and they want to put it into, for example, the PG&E fire cases. And that's it. And that's all we want. That's it. Just give us that. And then there are other lenders like Virage who want and are open to valuing really the world of contingent fee litigation. Because if we don't know the tort, we want to learn about it, right? Educate us on it, convince us that it's worthy. And so you just have all these different characters out there, but it all comes down to working with people who want to learn more and educate themselves. And that's why I like working with you, because you're always hungry to learn. You always want to know more. And I feel the same way. No day is the same here at Virage. I literally learn something new every day. Yeah. So anyway.
Yeah, I never really know how much I really know, because you're in that grind. And sometimes I'll pause and think, okay, I think I know enough, right? Yeah. To help folks. But then I realize, God, there's so much more. And as new sources of money is coming in from everywhere internationally, everybody does things differently. So you kind of have to see the investment mandates and how, the core values of the companies that are coming in and sort of what they're trying to accomplish, and then match people accordingly. So one thing I wanted to touch on, I didn't want to forget, because I get this question, there's a lot of misconceptions about this term in specific, is non-recourse versus full recourse money. Can you talk about that?
Sure. And that's great. I mean, that is something that confuses so many lawyers.
Yeah.
And if I just take one quick step back before I answer it, just to give it a little bit of context.
Sure.
No lawyer should enter into an exclusivity agreement with a company unless they have vetted their loan document.
Yeah.
And they know that they are going to do their best to close a transaction with that group. If you get a term sheet and nothing else, and it has a 90-day exclusive, and you sign it, I would tell you have not done yourself any good service. Why do I mention the loan document? That's where you find all of the terms, including recourse and non-recourse, that lead to what the cost of capital ultimately is. Any tie-up, like a prepayment penalty or mandatory debt service, any of those things, a lot of the true banking lenders, the alternative lenders that come from investment banks, are great at calling things that sound innocuous, but when you read into the paragraph, it's a tie-up. You're tied up. So let's just focus on your question with that background. I view recourse and non-recourse as sort of a misnomer. Lawyers who look at that term think it means I owe the money back or I don't owe the money back. That's how they look at it. I took $4 million. I don't owe it. I could throw it in the air and burn it in a fire, and I don't owe the money back. I could go off on vacation with it. I don't owe the money back. That's not the way it works. There are some lenders who use the term non-recourse, I believe, in a format that's meant as a shiny lure that gets lawyers excited. I want non-recourse money. Why do you want that? I don't want to owe it back if I lose. Well, hold on a minute. How many cases have you lost in your career? Meaning failed to monetize?
Mm-hmm.
I don't know, 2%. So wait a minute, you're going to work with somebody on this basis, likely for more expensive capital, because they're telling you that something is non-recourse. Yeah, that's right. Even though your life, your practice is that you're not going to lose. Well, yeah, I guess I'm doing that. I'm just nervous. It's a lot of money and I don't want to risk it. Well, did you read 8 paragraphs down where it talked about conditional defaults?
Mm-hmm.
No, I just thought that meant like if I stole the money or did something bad with the revenue that came in. No, read about it. It says here that if your loan to value ratio gets a little bit out of whack, a little bit, the lender can put you into an involuntary bankruptcy. You aware of that? No, I didn't realize. I just thought that the LTV, no, I didn't. Well, what about the part that said that if one of your partners leaves the firm, they can put you into an involuntary bankruptcy? Oh, oh my God. I haven't seen a what I'll call this unicorn of a here's money, and no matter what, other than you stealing the revenue that comes back, you're great. Don't worry about it. So I don't view that as a realistic thing when you look at the terms of a contract. Now, recourse. A recourse note is where you say, like with your bank, I borrow $4 million, I owe you $4 million. Whether the case wins or loses, I owe you all of that money. If I use my own money, it's full recourse, because if I lose it, nobody's going to pay me back.
Mm-hmm.
Virage takes an approach, traditional approach. It's not always, but 90% of the time, that has a blended recourse, non-recourse. And what it means is, if we loan against 3 torts, let's say, and all 3 torts fizzle out, they all lose. I'm giving you an extreme example, but they all lose. You borrowed $4 million, all 3 torts lose, barring bad boy acts, barring theft and all that. You don't owe us the money. Your traditional bank, you owe the money.
Yeah.
You lose it yourself, you lost that money. With Virage, that's your insurance against a catastrophic loss. Okay. Now let's flip it. Lawyers say, well, wait a minute, when do I owe you the money? If you borrowed $1 million and you recovered in a case resolution $3 million, we get paid back. That's easy. What happens if you borrow $1 million and 90% of your cases pay out, but you only get 99.999% of what you owe Virage back. In that instance, you owe us that penny or that dollar. And so what am I saying? I'm saying that if a lawyer is going to take a risk.
Wow, I had it on silence. Sorry.
So if our model, it basically protects a lawyer against a catastrophic loss, right? And the only risk that they face, in my view, is if at the end of the day, they get close to what they borrowed. And the reason why they have to look carefully at that, this mechanism was designed by Virage so that lawyers in Virage would have an honest conversation day one about the value of the dockets being encumbered. Okay. When we loan money, if somebody expects $1 million of fees, we do not loan them 100 cents on the dollar. So if we loan $1 million, theoretically 3, 4, 5, 6 million is coming in. So what would it take for $999,999 to come in? They would have to fail miserably in their minds to not get 2 or 3 or 4 or 5x on their investment. So we have a conversation, we have a dialogue. We think, and I think that Virage is unique among any lender out there in this approach that we take. Catastrophic losses, you're protected. And if you hit it, it's a win-win. And if you get really close on most of your clients, that was your bad. But that hasn't happened yet in 8 years. Yeah. That scenario hasn't unfolded.
I am actually working on multiple deals currently, and I'll get term sheets that say non-recourse, and will then in the next line ask for the client to pledge their home as collateral. That I have a hard time consolidating or understanding, but that happens very, very often. And I don't know, because it's hard to approach a lender and say, this doesn't make any sense. I mean, certainly if I pass on their offer, I'll just say the client is looking for, either full recourse or full, non-recourse, and wants to understand the difference. But I certainly see these term sheets come through my desk all the time that are very confusing. Do you think there is misconception about what recourse and non-recourse is amongst lenders in this industry? Or what do you think, what is your opinion, your personal opinion on that?
I don't know if it's confusion. I will tell you that Virage would not label our note non-recourse note. We just wouldn't label it that. And we certainly wouldn't go forward and say to a borrower, it's only non-recourse. I mean, we have a fairly specific paragraph that explains how it works. It could be non-recourse, could be recourse, right? But the things that make it recourse traditionally, in our sense, mean you've won something. If it's if it's truly non-recourse, you had a loss, a catastrophic loss. I think there are probably some alternative lenders who use that term to attract clients, borrowers. Mm-hmm. They don't have the purest of hearts on it. I think that's a possibility. I do think that there can be confusion, but I don't want borrowers focusing on that word because that word almost doesn't mean anything by itself. What you have to look at in the loan document itself is, and I tell people call me all the time and they say, look, we can't work with you because you didn't love our case collateral, but we're working with other people. And I've said, call me if you need advice. So what I tell them to do in this exact circumstance is draft an email in plain English to the lender and say, under what circumstances do I owe you this money back?
Yeah.
That's it. When do I owe you the money back? And second question, what is the cost of my capital? Mm-hmm. Meaning, if I pay you back in 12 months, what do I owe you? I borrowed $1 million. What do I owe you in 1 year? Yeah. Give me those numbers. I analogize it, Mirena, to, just regular folks like us. We go schedule a surgery. I mean, do you ever ask the surgeon how many patients have died on their table? Do you ever ask them how many malpractice suits they've had? I bet you 99% of the American populace does not. I will. Mm-hmm. And I will also encourage the borrowers to ask all the questions they want of us until they are painfully aware of everything that they want to be aware of. And if they're going to a competitor or even to folks who lend money that are not our true competitors, I want them to get honest and accurate information. So is there a misconception? Maybe. I just think it's a misnomer. It's a word that by itself doesn't mean anything. And I have never seen this unicorn of this true non-recourse. And if I have seen anything close, it costs a whole lot more. Mm-hmm. It just does, because you find it in those multiple and other transactions. So it's my 2 cents.
That is very helpful, very insightful. So where do you think the industry is going? Do you see the litigation funding world regulated at some point in the future? Do you see,
I see litigation finance evolving and becoming more specialized. I see it as firms coming in for the long term who develop great relationships with borrowers, but who do it, some in certain areas of the law, like intellectual property. Some of them who would do it, for example, in mass torts only. Some who might do it only on case expenses with personal injury clients. So specialization is my first prognostication, right, for the next several years. I also think, as far as regulation goes, I'm not sure. I mean, there are ethical responsibilities that lawyers have. There are, considerations that Virage has to take. We are regulated by the SEC. We take that very, very seriously. We have commitments to our investors. And I don't know if the government is going to step in more strongly in some way with oversight. I really can't speak to that at all, but I don't see that happening in the immediate term.
Yeah. Well, Marty, this has been really, really informative, very, very helpful. It's always a pleasure to connect with you, to talk with you. I've told you this many times. I've learned a lot from you over the years. Very grateful for that. And I'm excited about what the future holds. I think that you're bringing an incredible amount of value to your clients. Your standards are really some of the highest standards that I have seen in this business. So keep that up. And certainly I look forward to working together in the future. I appreciate your time on this podcast today.
Thank you very, very much. I've enjoyed it and look forward to talking again.
Sounds good. Thank you.
Be well.
It was great.